That's a problem. It's your criminal history. 96. That's one of the most I've done this for a long time. Thousands of cases. Well, you are one of the most prolific criminals that have set foot in this room. And I guess you have used similar kinds of sad stories to others to try to minimize your responsibility. But this is nothing to be proud of, and it's not anything that this court can really sympathize with you. People come in here, everyone comes in here. Maybe one or two out of the thousands have been more prolific in their criminal actions, quantity of crimes more than you. But all of those thousands of people that come before me could say, Miss Tiffany Marshall, she had 97 convictions, and you let her kind of sashay out of here. And I'd like the Tiffany Marshall rule, please, because aren't you supposed to be fair, Judge? Yeah, I am. I should be fair. And everybody is to be judged based upon their criminal history and character. And this is very poor character. And your criminal history is most prolific. This court is not going to change the rule of law, which states people are responsible for their bad acts, their criminal acts. They must be held responsible. Anything else?
Well, I don't know that all of the theft by check citations were convictions. I know that she said she handled most of her things by paying her checks off. But the other thing is, I would ask the court that if the court is not willing to allow her to be on probation, and even though she got a year, the last time she had a state jail felony, we would ask that you consider something on the low end, 6 months, or even a 1244, in light of her other problems that we would have to, as the taxpayers, have to deal with because she's so ill. So I would ask the court, if you're going to send her to jail, that you consider something on the low end.
Anything else? If not, on that argument, truly, then people who are seriously ill have carte blanche to do pretty much anything they want, and everyone has some form of situation health-wise that they're dealing with. Even the most healthy people are not perfect. I so find you guilty. I'm following this agreement. You are hereby sentenced to confinement in the state jail for a term of 15 months. You will be given credit for all time that you have served in accordance with this. Your lifestyle, see, Ms. Marshall, you have a lifestyle that you feel shocked that committing crimes should hold you accountable. You have 96 infractions of law, 96, and you are committing these crimes with special tools for getting away with attempting to commit your theft. You have specially made tools that are used in the commission of your crime. You can't, a judge cannot be lenient with you. You cost everybody. You are a one-person crime wave. It's thefts that cost everybody more money at merchandise stores because their theft, the loss is so high. We have to pay for your criminal acts. But after 96 times you have had to go deal with crimes in various courts, from felony courts to misdemeanor to Class C misdemeanor courts, you would have gotten the message, and you never have. You just are a career criminal. You're the very essence of a career criminal. And I wish you wouldn't do that. Thou shalt not steal. You've heard of that one. And it's not only written in moral issues, but it's right there in the law. There's a full section or two or three in the penal code which deal with dishonest acts, and that's where you are. I'm sorry. I just wish you'd have changed your ways. But like I said, you've been doing this for 30 years. 30 years. Okay.
Judge, can I get some time to get my stuff in order and go to my doctor to get my vaccine?
No, ma'am, not under this situation. The jail is going to be able, those people in the jail take care of people who have medical issues. I trust them. They are good at their job. I'm going to give you a chance during the Christmas season to go out and steal more stuff. I don't think so. Well, you've always done that. You've done that for 30 years, 97 times now.
Just tickets for traffic violations. So please, I got my grandkids living with me.
Ma'am, my God. Ma'am, you didn't think of all of that when you made a choice to steal? You didn't think of what you had to lose?
Yes.
And the people who rely on you or respect you or look up to you? I've got children. I've got grandchildren. They help me make the right choices, and it's not all that hard to think about them first. And you don't. You just thought about stealing for your needs. I'm sorry. I don't mean to. I hate being the Grinch here, but this is all about law or an order. And this is 97th time. 97th time, my gosh.
It's like all them times it's like tickets and
Ma'am, they were all crimes that you were found guilty of. They were all crimes. All of them were crimes. That is all. And make sure that you inform the jail about your health needs so that they can get the proper medication for you.
Comment your opinion, like the video, and subscribe for more real courtroom moments.
He was arraigned on March 2nd. I'm now sitting here a month later and no discovery's been picked up. Nobody's working on his case. Counsel, that's not how law is practiced. You all right? For calls the case of people versus Corey Jones. Basis.
Good afternoon, Your Honor. Edward Lucas on behalf of Corey Jones in 1318.
Good afternoon, Judge James Murray, P 5490, appearing on behalf of Mr. Jones on the subsequent matter.
All right, what are we doing?
Your Honor, today,
Your motion.
great, this is
Go
the eighth time for my motion to withdraw. First of all, I want to apologize for inconvenience of court. If so, I talked to mom. Well, actually, I was in contact with Mr. Jones's mother for his matter that brother counsel is on now. They were saying me on such matter. In the middle of negotiations for such case, he was arraigned on this new matter. In the rush and the haste of attempting to get off that case to make sure the arraignment went successful, failed to put limited on my appearance for the arraignment purposes. And after discussions with mom, she had decided to go in a different direction. So with that being said, I would ask that my motion.
Oh, but your motion says that the relationship between you and Mr. Jones broke down.
Correct.
Okay, but that's not what you just told me.
So to flesh it out more, I was speaking to Mr. Jones on behalf through his mother. His mother was the one who went through everything. His mother reached out to me. His mother kind of did all the contacts. Mr. Jones has been incarcerated in Washington all so far.
I know, but I'm trying to figure out what's the basis of your motion to withdraw.
Basis of the motion is that I was engaged by Mr. Jones's mother prior to the arraignment. She does not want to proceed with me as counsel.
Why didn't you say that in the motion? I guess because all this has done is delay Mr. Jones's matter. I just
Understood, Your Honor. I do apologize for the inconvenience.
well, it's not just apologizing to me, it's Mr. Jones. I mean, he's got a right to have his matter proceed forth, and now Mr. Jones, what do you want me to do? You know? Pam, grab that motion. Yes, Senator.
Yes.
Mr. Durkis, in your matter, what are you doing?
Your Honor, I sort of the tail, the other case is sort of controlling. I'd be asking for an adjournment to follow that case. My case is a fleeing matter. The other matter
I'm sorry.
is it just a fleeing case?
Pam, you don't have to take the baby out. That's what you're trying to do. I like hearing babies more than I do attorneys. You're all right. Okay. Thank you though for having that consideration. You're good.
And I believe it's a 15-year max on one of the felonies in the other matter. So I think that I don't have that report. I don't know much about it at this time.
Has the discovery been settled? I mean, where is his case at this point?
I have not received discovery on this matter.
Pardon?
I have not received discovery on this matter.
While in our office, I do have the discovery in our file media. But I'm not sure.
He was arraigned on March 2nd. And so nobody's been working on his case since?
The arraignment for, let me just clarify, for the case ending in,
The one you entered an appearance on. He was arraigned on March 2nd. I'm now sitting here a month later and no discovery's been picked up. Nobody's working on his case. Counsel, that's not how law is practiced. Ever. And certainly not here in Washington County. If you were going to withdraw, then you go ahead and you get the evidence. At least then when new counsel steps in, you can turn it over to them. But you don't do this way, and you don't do this to Mr. Jones. Have you ever talked to Mr. Jones?
not directly.
Then why did you lie in your motion?
When I spoke to his mother, she indicated she
Do
represents.
you have a copy of your motion? Look at paragraph 2.
Okay, I'm here.
Read it out loud. What does it say?
It states that there's been a breakdown of communication between Attorney James Murray and Jones.
How is there going to be a breakdown if you never talked to him?
Your Honor, from my perspective, I was speaking to his mother. Expressed Mr. Jones's wishes. I should have outlined that in my motion after discussing that.
Meaning you should have told the truth and had full candor to the court is what you should have had.
I'm explaining exactly what happened right now on the record. I was never attempting to mislead the court. I was speaking to.
No, you did mislead this court. You are making me, when I look at this motion, it appears that what has gone on is you and Mr. Jones are having communication, and for whatever reason, there becomes this irreconcilable thing between the two of you where you can't represent him. That's not it.
If I put a
You
minute,
never talked to him. And now he's a month out from the time that he's arraigned, and you never talked to him. You shouldn't practice criminal defense anywhere. Because your primary obligation is to your client, not his family, to him. Mr. Jones, what do you want me to do? It's your case, it's your life. What do you want me to do?
What do you mean? Like, as far as what?
An attorney. I know you got Mr. Drukas on that one, but do you want him representing you? For you, Mr. Jones, I'm going to grant the motion to allow him to withdraw because he hasn't done a darn thing for you. Don't come back into this county until you're ready to practice like you should practice. Goodbye. Goodbye. I dare you to slam that door. I'm calm. I'm good. Miss Gaines, on this case, I think he stepped in or did whatever he did, but I don't think the PD was ever appointed. And I don't know. I mean, I want to get his case moving along because if
If the public defenders is appointed, we can get that discovery over to them, say it was sensitive transfer, everyone, get that over to them, public service tomorrow, that would be hard to document, police court, media, not one or all the files.
all in, okay. And
We could
the
adjourn
only
when
thing
we,
that I'm worried about is you're on this other case
I'm on the other,
because of a conflict with the PD,
correct.
right? I'm just trying to make sure, is there going to be the same conflict? Because then we can try to skip that step. I mean, it sounds crazy, but skip that step to get somebody appointed that's going to represent him and talk to him about the case he's on.
Let me see if I can shepherd you.
Okay. Oh, bring the baby back. That's upset. He took the only person I liked in the courtroom out. What, are you worried that she's talking too loud? Are you? Don't really, I'm serious. Don't worry about it. If she's got something to say, well, I'm going to let her say it and we'll just all wait.
Nicolette. Oh, Mr. Jones. Okay.
Are they down in the back office? I think if they have a conflict, they have to figure out some way to do that and then get.
Typically comes.
Right, yeah, exactly, but I think what I need to do is appoint the PD first, then get the order withdrawal and appointing you, since I don't do the appointment, but. Okay, tell them, are they hearing it? They probably, I don't have them on.
No, they're not.
Can you let them know that on Mr. Jones' case that and tell them which one it is, and that Mr. Drukas has his other case. And we're not sure whether the PD has a conflict. Mr. Jones, I apologize to you. This is not the way it's supposed to happen, but I didn't do it, but we're going to try to make it as right as we can. All right. No, I just say, I just say that.
Based on Mr. Gaddy's look, I think we will likely have a conflict on this matter.
On this one.
Yes.
Okay, then the approval chain to appoint counsel for him. Can you do that, Ms. Gaines? Can do that? Okay, so here's what I'm gonna do. This is gonna sound really weird. But I'm going to appoint the public defender. The public defender will then have a conflict. I then need an order from the MAC office.
I can,
And maybe I don't have to wait for the paperwork. Can you ask them that if the PD has a conflict, which it looks like they do, they'll get that. Will they be appointing Mr. Drukas? Because then I can proceed with this matter and we can go and we'll just follow up on the paperwork.
Mr. Drews wanted to make sure that discovery gets to them tomorrow.
I'd ask for the week adjournment so I can review discovery if it does come to
See
me,
where-
and then we can come.
The only, I just can't appoint you myself.
Yeah.
And so I have to wait from a verification from them that that's what they're gonna do. To who? She doesn't have an answer yet. She should have an answer already. Type in this. Judge wants to know what's taking so long. Well, I think here's what I do, since it's a PD case at this point. I'm just going to adjourn both cases out to the 9th. We'll just make sure to follow up today with all of the paperwork. Okay, on that. So I'll adjourn both cases, probable cause conference, April 9th, 2026, 9 a.m. Bond will continue in both cases. All right, Mr. Jones, you understand kind of what's going on?
Yeah.
Got it. So one of two things will happen. It's likely that there's a conflict there, and so that you'll have Mr. Drucas in both of your cases. Okay. If not, worst case scenario, you'll have Mr. Drucas, you'll have the public defender on your case. But you got an attorney that's going to represent you. Okay. All right. We'll see you next.
The council just wanted to send a appearance direct, so we know who to send it to tomorrow.
Right. Okay. They'll make sure. All right. Thank you.
Thank you, Your Honor.
That's it.